What's trade dress? If you're a guitar person, you know which brand is associated with a slanted headstock. If you enjoy vodka, you know which brand is sold in a skull-shaped bottle. If I describe a shoe with a distinctive red lacquered sole that contrasts with the rest of the shoe, you know exactly which brand I'm talking about. How about a tall, narrow drink can with large blue and white rectangles on it with some red text in the middle? Or a fast food kids meal container with two arches at the top? Now, I did not say the name of any of these brands, and I did not show you a logo. I just described how something looks, and you knew. That's the power of a trade dress trademark. Here's the gist of a famous trade dress trademark case, and I had two clients who had something very similar happen to them recently. Imagine you spend years building a restaurant. You develop a distinctive look, a particular color scheme, a unique interior design, a specific way of presenting the food. Customers recognize your place before they even read your sign. And then a competitor opens up 3 miles away with the same color scheme, the same layout, the same vibe, but a different name. They're copying everything about how your business looks and feels. They're trading on the recognition you spent years building, and they're doing it legally because it doesn't involve a logo or a name. Or are they? Is there anything you can do? Welcome to Spellbinding IP. I'm Julie King of King Patent Law, your rock and horror-loving patent and business attorney, here to help you find and use every legal tool available to protect your business and brand. Now, I may love horror movies, but I don't love it when businesses encounter real-life operating horrors that could have been avoided. Today, we're talking about trade dress. It's the IP protection that most small business owners have never heard of, but it can protect everything that makes your business visually distinctive, above and beyond your name and logo. Now, a quick note before we get into the details. If you're a product inventor and you want to know how design patents and trade dress work together as a two-stage protection strategy, specifically for product aesthetics, I do have a separate video on that called The Two-Headed Monster of Design IP. The link is in the description. Today's episode is broader. Trade dress for restaurants, retailers, packaged goods, websites, any business with distinctive visual identity worth protecting. And that applies to creators, too. Now, here's what we're going to cover: what trade dress is and how it differs from regular trademarks, the legal requirements for trade dress protection, 4 real cases that show how this works, how to register your trade dress trademarks, and a practical step-by-step to start protecting your visual identity right now. So let's take the white ribbon off of the Tiffany blue box of trade dress trademark law and see what's inside. Trade dress is a form of intellectual property protection that covers the overall commercial image or appearance of a product or business. It falls under trademark law specifically. It is protectable under the Lanham Act, the same federal statute that governs trademarks. Now, where traditional trademark law protects words, names, and logos that identify the source of goods and services, trade dress extends to the total image and visual appearance. It covers the combination of elements that, taken together, create a distinctive look and feel that consumers associate with a particular source. Trade dress can intrude product packaging, the distinctive shape, color, and design of how a product is packaged. The classic Coca-Cola contour bottle is a registered trade dress trademark. The overall look of a perfume bottle. Product configuration, the shape or design of the product itself, such as the distinctive shape of a piece of furniture or candy. Interior design, the layout, decor, color scheme, and overall look and feel of a retail store or a restaurant. Apple stores have a distinctive layout, lighting, and design that is a protected trade dress trademark. The Hard Rock Cafe has distinctive rock and roll decor as its trade dress trademark. The famous 2 Pesos versus Taco Cabana case, which we will get to in a moment, was specifically about restaurant interior design. Website and user interface design can also be a trade dress trademark. In some cases, the distinctive visual design of a website or digital product can qualify as trade dress, though this is a developing and fact-specific area. Color combinations. In limited circumstances, a specific color or color combination can be protected as trade dress. 2 recent lawsuits show exactly how this works and where it breaks down. In 2012, the Second Circuit Court of Appeals decided Christian Louboutin versus Yves Saint Laurent America. Louboutin has held a federal trademark registration for its red lacquered outsole since 1992, when Yves Saint Laurent released a fully monochromatic red shoe, red upper and red sole together. Louboutin cried infringement. The court found Louboutin's trademark was valid, but it was not infringed by a monochromatic red shoe because the registered mark specifically requires the red sole to contrast with the upper. A shoe that is entirely red, sole included, falls outside the mark's protection. So the important takeaway here is that a single color, used consistently as a source identifier and formally registered, can be protectable trade dress. But Louboutin had been building and enforcing that red sole for decades before the court backed them up like that. The protection did not arise overnight. Now here's a case that shows what happens when the trade dress claim goes the other way. And this one is still developing, so it's worth watching. Scott's, which makes the Miracle-Gro line of lawn and garden products, has sold those products for years in distinctive green and yellow packaging. In 2024, Scott's sued Procter & Gamble after P&G launched a new weed killer called Spruce in, you guessed it, green and yellow packaging. So the federal district court in Ohio denied Scott's motion for a preliminary injunction in June 2025 in Scott's Company versus Procter & Gamble Company. The court found that Scott's had not shown a sufficient likelihood of consumer confusion. Among the factors, Spruce used a darker shade of green and a distinctive transparent panel that set it apart from Miracle-Gro. And critically, there was no evidence of actual confusion among consumers who had already been exposed to both products in the real marketplace. Procter & Gamble's argument cut right to the point. Green and yellow, P&G contended, are the colors of grass and sunshine. No company should be able to claim a monopoly on the colors of the lawn care category itself. Scott's dilution claim fared no better. The Sixth Circuit applies a more demanding similarity standard for dilution than for infringement, and at the district court level, the products were too dissimilar to clear that bar. Now, Scott's has since appealed to the Sixth Circuit and made its arguments last week, April 22, 2026, so the final chapter of this story has not been written yet, but the district court decision gives us a clear lesson. Claiming trade dress in a color combination that is widely shared across an entire product category is a steep climb, no matter how established your brand is. Put Louboutin and Scott's side by side and you see the principle. A color can be trade dress, but only when it functions as a source identifier in the eyes of consumers, not when it describes the product, reflects the category, or is used too widely to point uniquely to you. Now let's look at the requirements for a trade dress trademark. For trade dress to be legally protected as a trademark, it must be both distinctive and non-functional. Let's look at each one of those requirements. Distinctiveness can be inherent or acquired. Inherently distinctive trade dress is unique and unusual enough that consumers would naturally treat it as a source identifier from the very first encounter. However, this applies only to product packaging, not product design. Acquired distinctiveness, also called secondary meaning, means that through long and consistent use in commerce, usually at least 5 years, consumers have come to associate the trade dress with a particular source. The look started as just a look. Over time, through advertising, sales, and consumer experience, it became a source identifier. For most small businesses starting out, acquired distinctiveness is the more realistic path. You establish your distinctive visual identity, use it consistently across every touch point, build consumer recognition over time, and your trade dress gradually acquires the protection that comes with being recognized as a source indicator. Distinctiveness was at play in the battle between Dan Aykroyd's trade dress trademark for his Crystal Head vodka and Element Spirits tequila, also sold in a skull-shaped bottle. That case lasted 9 years from the initial filing to final order, which shows how big of a deal these trade dress issues can be. Now let's look at the hard limit of non-functionality. Non-functionality is a little less nebulous than distinctiveness. Since the mid-1990s, trade dress that is functional cannot be protected, regardless of how distinctive it has become. Trademark and trade dress law are about source identification, not about giving one company a permanent monopoly on useful product features. That is what patents are for. The Supreme Court held that since trademarks can last forever if maintained properly, allowing trademarks to include function would do an end run around a patent's 20-year limit and thus stifle innovation. So what does functional mean? A feature is legally functional if it is essential to the use or purpose of the article, or if it affects the cost or quality of the article. Functional elements are things competitors need to be able to use to compete effectively. Decorative, ornamental elements that serve no function other than to identify source or simply look cool are the protectable ones. The Louboutin red sole passed the functionality test because the color served no physical purpose. It was purely a visual identifier. But if the red sole had had any performance function, that claim would have failed. Gibson guitars ran into this problem with its distinctive Les Paul single cutaway body shape. Now, it's certainly distinctive, but it's also arguably functional because it does allow the player to access the higher parts of the strings more easily. Now, fortunately for Gibson, an infringement lawsuit in the early 2000s that brought up that very issue was decided on other grounds and didn't fully address the issue. Now, the Gibson Flying V guitar shape is another of Gibson's trade dress trademarks, but that design doesn't affect the functionality. It's merely decorative and looks cool, so it's safe. Now for that restaurant case I mentioned. Cabana was a chain of Mexican restaurants in San Antonio, Texas, with a very specific, distinctive look, a festive interior with patio dining, brightly colored murals and artifacts, and a particular exterior appearance. Two Pesos opened competing Mexican restaurants in Houston, Texas, with an interior and exterior design that Cabana said was strikingly similar. The case went to the Supreme Court, and in 1992, the court held that inherently distinctive trade dress can be protected under the Lanham Act without proof of secondary meaning. If your trade dress is distinctive enough from the start, you do not have to spend years building consumer recognition before you can go after copycats. That is the inherent distinctiveness advantage I mentioned before. For a small business with a genuinely distinctive look, this is important. You do not have to be a national chain or a big corporation before your visual identity deserves and can have legal protection. But remember, in 2000, the Supreme Court clarified in Walmart stores versus Samara Brothers that product design, the shape of the product itself, is never inherently distinctive. For product design specifically, acquired distinctiveness must be shown. Presentation versus product, it matters. Now let's talk about what happens when someone deliberately targets your famous trade dress and claims it's just a joke. In 2013, VIP Products released a dog toy called Bad Spaniels, shaped to resemble the iconic Jack Daniels bottle. Where the Jack Daniels label reads Old No. 7 Brand Tennessee Sour Mash Whiskey, the toy substituted scatological wordplay. Jack Daniels sent a cease and desist letter. What followed was more than a decade of litigation that reached the United States Supreme Court. Yes, dog toy versus whiskey went to Washington. In 2023, in this case, the Supreme Court addressed whether VIP could use the Rogers test, a First Amendment-based defense originally developed for expressive artistic works, to shield a commercial product that mimicked a famous mark. The court said no. When someone uses a mark as a designation of source for their own goods, the Rogers test does not apply, and the traditional likelihood of confusion analysis governs. On remand, the Federal District Court in Arizona reached a split decision in January 2025. On trademark infringement, the court found that Bad Spaniels was a successful parody. The toy clearly referenced the original while creating enough contrast and humor that consumers were unlikely to think that Jack Daniels had made or endorsed it, so no trademark infringement. But on dilution by tarnishment, the court found liability anyway. And here's the irony. The very qualities that made the toy a non-confusing parody, the crudeness, the irreverent association of a premium whiskey brand with bathroom humor, were exactly what tarnished Jack Daniels' reputation. The more over-the-top the joke, the less confusing it is, but also the more reputational damage it can inflict on the famous mark. The court put it clearly. Even a non-confusing parody can violate the Lanham Act if it harms a famous mark's reputation through negative associations. Trademark infringement and dilution by tarnishment are distinct causes of action protecting different interests, and the defendant can win on one while losing on the other. The practical lesson for anyone thinking about using a famous trade dress in a parody product: the more irreverent your humor, the more you may actually dodge an infringement claim, but the more vulnerable you become to a tarnishment claim, especially when the mark is famous. The more famous the mark, the greater the potential harm that can be claimed, and unlike Joan Jett, most businesses do give a damn about their bad reputation. So what do you have to do to protect your trade dress trademark? You don't have to register your trade dress to have rights in it. Common law trade dress rights arise through consistent use in commerce, just as common law regular trademark rights do. But federal registration with the USPTO provides significant advantages: constructive notice to the world that you claim the trade dress, a legal presumption of validity and ownership, the right to use the registered trademark symbol, and access to federal courts with stronger remedies. Trade dress registration is more complex than a standard wordmark or logo registration. You will need to describe the elements of the trade dress clearly, establish distinctiveness, unless it's inherent, and that's tricky to do, and address whether the elements are functional. For acquired distinctiveness claims, you will likely need to submit evidence, including sales figures, advertising expenditures, and consumer declarations. The USPTO scrutinizes trade dress applications more heavily than wordmark or logo applications. Working with a trademark attorney is particularly important for trade dress trademark registration. The description of the mark, the identification of the specific protectable elements, and the strategy for demonstrating distinctiveness all require careful handling and guidance. Here's the practical sequence to protect your trade dress trademarks. Step 1, identify your distinctive elements. Look at your business and make a specific list of the visual elements that make it recognizable, not the name or the logo. Those are regular trademark territory. What else? Your color palette, your packaging design, your storefront appearance, the layout of your retail space, the distinctive shape of your product, your website's unique visual style. Now, be specific. We use purple is not trade dress. We use a consistent combination of deep purple, mint green, and matte black across all packaging, signage, and physical space, creating a distinctive visual experience that customers associate with our brand is closer. Specificity matters, both for understanding what you have and for any eventual registration claim. Step 2, document everything. I know I say that all the time, and there's a good reason. It's very valuable. Date your creation of these elements. Keep design files, photographs, sketches, the original design brief. If you ever need to establish that you created and used these elements before a copycat, documentation is your evidence. Cloud storage with automatic timestamping is useful here. Step 3, use it consistently. Trade dress protection develops through consistent use. If your distinctive elements appear in some places but not others, if the color scheme shifts between your physical location and your website, if the packaging varies too much across product lines, you're undermining the distinctiveness claim. Consistency is not just good branding, it is legal infrastructure. Step 4, consider registration. If your business has significant visual equity, meaning customers recognize your brand from the look before they see the name, talk to a trademark attorney about trade dress registration. The investment will likely be higher than a standard wordmark registration because all that evidence proving acquired distinctness has to be pulled together and presented properly. But for businesses where visual identity is central to the brand, it is often worth it. Step 5, police it. Trade dress trademark rights, just like other trademark rights, require enforcement to remain strong. If you see a competitor copying your distinctive visual identity, act early. A cease and desist letter from an attorney sent promptly sometimes resolves the situation without litigation. Waiting or allowing the copying to continue unchallenged can actually weaken your legal rights. The Jack Daniels case is a useful illustration here. Even when policing your trade dress does not produce a quick resolution, and a decade-long dispute is far from quick, enforcement still matters. Jack Daniels did ultimately prevail on that dilution claim. Step 6. Get legal help early. The moment you believe someone is copying your trade dress, contact an attorney. Trade dress analysis is fact-specific. Early legal involvement gives you more options and better outcomes than waiting until the copying is well established. Here are the key takeaways from this episode. Number 1, trade dress protects the overall visual appearance of your product, packaging, or business, including color combinations, product configuration, and interior design. 2, trade dress must be distinctive and non-functional to be protected. You cannot lock up useful functional features with trade dress, and the Scott/Miracle-Gro case is a reminder that you will also have a difficult time claiming a color combination that the whole industry shares. 3, you do not have to register to have trade dress trademark rights, but federal registration provides significant legal advantages. 4, the 2 Pesos case established that inherently distinctive trade dress can be protected without proof of secondary meaning for product packaging and business presentation. For product design itself, acquired distinctiveness must be shown. That's the Walmart versus Samara Brothers rule. Number 5, document your distinctive elements. Use them consistently and enforce your rights promptly when you see copying. Number 6, parody is not a get-out-of-jail-free card. Even legally successful parody can lose on dilution by tarnishment if it harms a famous mark's reputation, as the bad Spaniels case makes very clear. Now it's FAQ time. Question: can I protect my website design as a trade dress trademark? Answer: potentially yes. Website design and user interface can qualify as trade dress if they are distinctive and non-functional. This is a developing area of law, and this analysis is fact-specific. If your website has a highly distinctive look that customers associate specifically with your brand, it's worth discussing with an attorney. Question: what is the difference between trade dress and water image trademarks? Answer: traditional trademarks protect words, names, and symbols like your business name and logo. Trade dress extends to the overall visual appearance and commercial image, including packaging, product shape, color combinations, and store design. Both are governed by the Lanham Act and can be federally registered. Question: how is trade dress different from copyright? Answer: copyright protects original works of authorship, such as the specific graphic design of a logo or photograph. Trade dress protects the commercial impression created by a combination of elements as a source identifier. A distinctive product package might be protected by both copyright in its specific design and trade dress in its overall look. They are different rights protecting different aspects, and in some cases you can hold both simultaneously. Question: can someone use my trade dress in a parody product? Answer: this is exactly what the Bad Spaniels litigation tested over more than a decade. The short answer: it depends on what claim you are bringing and how famous your mark is. A parody that is sufficiently distinct from your mark may not create a likelihood of consumer confusion, which means it may survive a trademark infringement claim. But if your mark is famous and the parody harms your brand's reputation through negative associations, the parody may still be found to dilute the mark by tarnishment, even without any consumer confusion. The 2 legal claims protect different things. Infringement protects against confusion about the source, and dilution protects the reputation and distinctiveness of the mark itself. The practical lesson: if someone is selling a commercial product that mimics your trade dress, even as a joke, contact an attorney. The analysis is fact-specific, and a dilution claim may be available even when infringement is not. Question: does trade dress trademark registration make sense for a small business? And the answer is it depends, of course, on how central the visual identity is to your brand. If customers recognize your business from its look before they even see your name, a restaurant with a distinctive interior, a product with a distinctive packaging system, registration can be worth the investment. Talk to a trademark attorney before you commit to a registration strategy. That's all for this episode. Thank you for watching or listening. If you're ready to protect the look and feel of your business, book a consultation at kingpatentlaw.com. I do serve entrepreneurs across the U.S. Avoid those legal horrors and keep rocking your IP. This information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney. This episode contains attorney advertising material. Law firm address and other contact information is in the show notes and bio and available at kingpatentlaw.com.